Should I add my child to title? Take your tax base with you using Prop 19, and how to give loved ones access to your tech after you've passed on. These are some of the things you'll learn today in our video. I'm excited to present Sophia Sakamoto, estate planning attorney, who's going to run through some of the estate planning tips and tech tips to help make life a little easier for your loved ones. Hope you enjoy. My name is Marvin Phillip. Some of you may not know, with the Phillip Group at Y Realty. And we have Sophia Kim Sakamoto with Sakamoto and Ruelas. Sophia is the owner and managing partner at Sakamoto and Ruelas APC, has over 15 years experience in estate planning, trust administration, probate, and business law. She has 2 offices, one in Buena Park, one in Mission Viejo. Her firm's able to assist clients in English, Spanish, and Korean languages. Sophia, the floor is yours.
Thanks so much, Marvin, for inviting me today to speak. And thank you all for joining me on this Tuesday afternoon. I hope your day is going well. And I hope you learn a lot from today's webinar. It's going to be a lot of information, and I don't expect you to learn every single thing, right? But if you can just identify the issues, kind of remember like, oh, I think she, said something about that, issue spotting, right? Then you're halfway there. So just a little bit about our firm. We, just as Marvin said, we handle estate planning, living trust, power attorneys, probate, and trust administration. We're currently at 4 attorneys, so we just hired another wonderful attorney just this month. So we are growing, and as you can see, we are a women and minority-owned firm, local to Southern California, with offices in Buena Park and Mission Viejo. And just a little bit about me: I have over 15 years of trust and estates experience. Went to UC San Diego, got my law degree from the University of Pacific McGeorge. Grew up in Cerritos and currently living in Cyprus. I also speak Korean for those who would like to have clients who need to speak in Korean. Just a quick disclaimer, right? So this is just information that is very general. It's not legal or tax advice, right? Everyone has a different and unique situation. If you do have a very specific question, I encourage you to contact us offline, or you can write it in the chat. If we have time, then we can answer those questions. So getting started, will my estate go through probate? First of all, estate. That is just the assets that you own. It could be a house, real estate. It could be bank accounts, a retirement account, a business, right? So it's pretty much everything that you own. Will it go through probate court if something happens to you? Maybe, right? In California, the rule to know is that if you have assets over $184,000 in just your name, so that could be, if you have a house, it's going to be more than that, right? And if it's just in your name and you're not here, where does it go, right? So then if you don't have anything written down, or if you just have a will, you might be in probate court. Because if something happens to you, where does it go? And only the court will be able to decide that unless you have things in writing. Now, what are things that are not going to go through probate? So what if you don't own real estate, but you have a really high worth in terms of like a IRA or like a 401k? So if you have accounts that are jointly owned, maybe your house is like husband and wife joint tenancy, something happens to you, it's joint, so then it would just go to the other. No probate. But the question is, if you're both not here, all right, it's probably going to be in probate court. So assets that are jointly held, a joint bank account, a joint real estate, may not go through probate if one passes, right? It just goes to the other. Assets held in a trust, a living trust, right? Those do not go through probate because it's held in the name of the trust, not in your name only. That's the difference. And then with IRAs, if you have beneficiaries designated, then of course, if something happens to you, it goes straight to that beneficiary. Even if you have a trust, it will just go to whoever is the named beneficiary on those accounts. So if you have a really old IRA, or maybe like a 401k that you had before marriage, before your second marriage, or maybe your spouse passed, this would be a good time to review and update those beneficiaries. Also, if you had this account when your kids were little, right? Maybe they're over 18 now, this would be a good time to review and update those IRA beneficiaries. Life insurance and annuities, you probably know if something happens to you, right? We would need to name a beneficiary and it goes straight to them. That does not also go through probate court. Now, If it happens that the beneficiary is not there, or like you forgot to put someone on there, then, where does that life insurance go? Where does that IRA go? It will have to go through probate court because, again, the probate court will decide who gets it. Okay. Now, if you have a business, right, that's also value. It has value. It's in your name. Where's that going to go? So what we currently do is we have to make an assignment for that share to be put into the living trust. So you, as the trustee of your trust, is the owner of this business, the LLC. Now, the LLC has its own, a business, maybe real estate, but at the end of the day, who owns that LLC? Right? Hopefully it's your trust, so that if you're not there, right, who's going to sign for you? Who's going to close that LLC? Who's going to sell it? Who's going to transfer it? Hopefully it's in your trust so that the next trustee will be able to sign things and do things for you. Otherwise, again, it's going to have to go through the probate court, where the court will decide who is the one that's going to sign things and transfer things. Now, in talking about generational wealth, right, what is that exactly? It's like, we want to build up. You work so hard. You made, you got this house, you got this business, you have this wealth, and you want to pass it down to your kids and their kids and just let it go for generations, right? And that's what the focus of this webinar is, to think of ways where we can save in taxes, some strategies where we can pass it on to the next generation. And life insurance is going to be one of those strategies too. Life insurance, as you know, it's really not for you, because if you're not here, like, you're not going to get to use it. It's for your spouse, your kids, right? So that they are able to use those funds for whatever they need to do. For example, if you pass, you might be losing an income source, right? So that life insurance could be there to help with the day-to-day, right? And it doesn't mean that, like, let's say you get $1 million in life insurance. It doesn't mean, you just use it all and pay off the mortgage or something. You could, or you could also put it away and invest it and maybe just live on the interest. That's happening too. If you have little kids, right? Very important to think about life insurance. Do you have a mortgage? Do you have little kids? If something happens to you, right? Hopefully that life insurance can go take care of that mortgage and more to take care of them as well. And of course, if you have dependents or beneficiaries, then of course, providing for them. Life insurances can be a very good tool to do that. I have a very close life insurance friend, and he always says life insurance is kind of like a love letter to your family, right? So very important to have that. And if you don't have that as part of your estate plan, consider looking into that. Did you know that you can also have a living benefits rider? Life insurance is for death, right? But sometimes, ask your insurance agent, they have something called a living benefits rider. Well, even though you're alive, if you have like a terminal condition or some kind of illness, you may be able to use some of that while you're still alive, instead of only at death. So there could be a living benefits rider on some life insurance policies. And then, of course, if you have a business, or if you're like if your income is highly dependent, right, with your family, consider disability insurance as well. So those are all strategies. Now, how can I avoid going through that probate court process, right? And of course, in California, especially in LA and OC, it's taking like 2 years to finish, and it's very expensive. Well, of course, first thing, you need to get a revocable living trust. If you have real estate, if you have kids that are under 18, a revocable living trust is going to be super important. So your family members don't have to go through that probate court process. So your kids don't have to go through a guardianship court process, so that their inheritance is taken care of by people that you choose, and that things will just go smoothly. It's just paperwork at that point, once you have the living trust set up. If your company shares are held in the trust, that's one way to avoid probate as well. You also want to think about, how is the title of my property held? Is it in joint tenancy, or is it in community property? I had a client come in last week, and they were not married, but they had a joint tenancy. So as one person passes, it all goes to the other. Now, he's like, I didn't know that, because he had kids and she didn't, right? And they're not married. So what does it say on the title? Very good time to review that right now. And if you're married, of course, community property with right of survivorship is also going to be important. What's the difference between joint tenancy and community property? Well, it could be a tax benefit too. You should talk to me later about that. Beneficiary designations on accounts, of course, make sure you have those right beneficiary designations on your accounts, IRAs, 401ks, life insurance, and even maybe like a savings account. You could put a transfer on death beneficiary as well. In California, they have something called a transfer on death deed. This was fairly new, where if you had a property, it's not joint, it was just you. Instead of doing a revocable living trust, you could do a transfer on death deed. It's very simple, right? It says if I'm not here, it goes to so and so. Now, the good thing is that's very simple, but at the bad thing is that what if that person's not there? Then there's really no like, okay, then it goes here and here and here. They don't really have anything like that. That's where you would get into the revocable living trust. So if you're thinking, I just need something really simple, I really don't have to do like a whole big, revocable living trust, perhaps a transfer on death deed could be an option for you. And if you have a small estate, which is less than the threshold amount, you can also that won't go through probate as well. That's really just some paperwork. Like, for example, you have a bank account and it's like $40,000 or something like that. You don't want to open a whole new probate for that. You can just do some paperwork and affidavit. If some of my clients have like real estate out in like, what is it, Kern County or something, it's like a plot of land, a vacant land, then, they don't want to have to open a whole probate with that. There is some simplified procedures. Now, there are so many different types of trusts out there, so I'm just going to talk about a few. Revocable versus irrevocable trusts. Now, a revocable trust means you can make changes. So right now, this is what you know. Kids get older, things happen in your life. It's flexible. You can update this. You can change things around. But because you can do that, those assets are still part of your assets, which means if you get sued or something happens, they're still part of your assets. So the revocable trust does not offer any asset protection. But there's something called an irrevocable trust. Once you set that up, you can't change it. It's out of your control, right? You put the house into the irrevocable trust and that's it. Now it's good because you've taken it out of your estate. It doesn't count for your estate tax calculation, right? You lose control over it. So you have that asset protection. It's not yours, even if you get sued. But the bad thing is, of course, you can't make changes to it. Now, if you did have a revocable living trust and you pass away, you're the only one that can make changes. So at that point, when you pass, the assets in the trust and the trust itself become irrevocable. Okay, so having said, that's kind of like the structure, whether something is changeable or not. But within these trusts, you can have several different types of trusts. I'm just going to list these because I feel like a lot of people haven't heard about these different type of options before. So sometimes my clients are married, but they have assets from a prior marriage. Maybe they have a big inheritance and they don't want to combine it. They don't want to make it community property. They say, if something happens to me, I don't want it to all go to my spouse. I want it to go to my side of the family, my kids, someone other than spouse. Then you can create a separate property trust. So sometimes my clients have 3 trusts. They have a separate property trust for husband, a separate property trust for wife's assets, and then they have a joint community property trust. So you can have several different types of trusts. There's also a trust for your minor child, right? Anyone who's under 18, they can't handle things. They can't like write checks. They can't manage money. They can't enter into contracts. They can't do anything. So you would have to create a trust if mom and dad are not here, or if they're not here, and someone else can manage the trust for the minor child. Sometimes my clients don't have kids, but they have pets who they love and they want to take care of. And there's something called a pet trust where if you pass, you set aside a certain amount of money. So for example, like $10,000, 50,000. I had a client who did like 100,000, right? And you set it up in a separate trust so that the trustee can use those funds for the care of the pets. And eventually they will be able to decide, who gets the pets, and whatever's left in that pet trust would go along with them. I usually put it, so that's only for 6 months, and you have to do your best to find someone to take care of the pets. And the last resort would be like a no-kill shelter. So that's just kind of an example. A gun trust. I had a client come to me and they're like, oh, I was like, okay, someone passed. You have these guns. What'd you do with these guns? They're like, oh, I just gave it to blah, blah. I was like, oh my God, you need to have like permits and licenses and all these things. And a gun trust would protect the trustee from that liability. What if you had a gun and something goes off and the police are like, where did you get this gun, right? So we need to put that in a gun trust so that the proper way to transfer that through a third party is what the trustee would need to do. A special needs trust for those families who have special needs children, children with a disability, and maybe they are receiving government benefits. You should definitely consider a special needs trust. Usually the government benefits are because the child doesn't have income, right? They're not making money. So they provide these government benefits. But then when mom and dad die and they get this inheritance, they're like, the government's like, okay, you have money now. Why do you need our money? And they stop those benefits. So putting the inheritance in a special needs trust, which means that you can get the government benefits and the inheritance too. Of course, there's some rules about that too. But if you do have a special needs child or know someone who's receiving these government benefits, definitely look into that. Charitable trust, usually for tax reasons, right? Where the beneficiaries would be some charities if you have a very big taxable estate and you want to reduce that. A legacy trust, this is like if you have kids and you don't want to give them all of it, all the inheritance all at once. Maybe you put the principal in a legacy or a dynasty trust, sometimes called a dynasty trust, and maybe they get the income every quarter, every year, but they don't ever get the principal, and that principal just transfers from generation to generation. So you can do something like that as well. If you have kids where you're like, oh, I don't know about their spending habits, maybe they've got some drug gambling like situation where you feel like they're going to use all the money and you want to be able to provide for them, this legacy or dynasty trust would be a good option or something to look into. Right of occupancy, I think in the last week I got like 3 clients asking about this. They kind of they just come in waves, right, with these type of issues. But usually if it's like a couple, maybe they could be married or not, but the issue is that when one person passes, they don't want maybe other family members, other beneficiaries to kick out their partner. They want to give them a right of occupancy to live in this house until they move away, until they die, until everyone agrees to sell the house. So these are some terms that can afford protection or security for the person who's going to be remaining on that property. And then, of course, an IRA trust. Typically, I usually name people as beneficiaries of an IRA. However, if you have an IRA that is very large and maybe you have multiple beneficiaries, and you don't want to just name like 20 people on that beneficiary list, sometimes it's a good idea to make a special trust to hold this IRA as well. And of course, many more. There's so many different types of trusts out there. Very briefly, in talking about generational wealth and transferring properties to the next generation, we really have to think about capital gains tax. Now, this is going to be maybe one of 2 tax topics that I'm going to talk about today, because it's so important when thinking about the next generation. Now, capital gains is when you buy real estate, or it could be stocks or a business. When you have an asset and you say you bought it in the year 2000, and then you go to sell it today, if it did increase in value, you have to pay taxes on that gain, right? How much it went up. Typically 15 to 40% state and federal could be taxable for that gain. That's a lot. Now, this is a very, very basic math calculation here. Of course, there's a lot of things that go into it, but say you bought a property in 1990 for $100,000. And then you sold it in 2023 for $500,000. Typically, there's a $400,000 gain, and you would pay taxes on it. Now, this is, of course, like I say, just very simple math, right? But is there a way to reduce that, right? How can I get rid of that, right? Or avoid these capital gains? If you sell the property during your lifetime, right, you're going to see that gain and you may have to pay some taxes on it. Of course, there's certain exceptions, right? If you lived at the house and so forth, but generally, if you pass away and your kids inherit this property, then there is a step up in tax basis to the date of death value. This means that you bought your house in 1990, right? You passed away this year. Now the starting line to calculate your gains is not from 1990, it's from the date of death, today. And then when your kids go to sell it, maybe it's the same year, they potentially have zero capital gains tax or very minimal. And I get this a lot. What if I just add my child to the title? Why can't I just give them the property right now? Why can't, if it's just me and my husband, why can't I just add a third child and just all of us be joint tenants? I get that question daily. The good thing is, yeah, it's going to avoid probate, right? If mom and dad pass first, it goes to the one on title, right? And it's also good because then the child firmly has the title to the property. There's no question. They're right on the title, right? But the bad thing is that you have to remember you're adding the child to your property. So they are part owner now, which means they have joint liability. And what if mom and dad is like, we want to sell the house? Then they're going to have to get agreement from everybody. And maybe the child is like, no, I want to live here. Like, I'm not selling, right? So you can have those kind of issues as well. And of course, there could be issues with property taxes, right? Anytime there's like a change in the owner, anytime there's a change in the deed, the county is always looking, can I reassess this property, right? And there could be an issue with that. And most importantly, capital gains tax. What does this mean? Well, when you gift that property to your child, the donee, the one who's receiving, takes on the donor's, the parent's tax basis, which means the child takes on the parent's basis when they bought this property, like say back in 1990. So they got the property in 1990 for 100,000. In January, the parent adds the child to the title, right? And in March, they die. The value is 500,000. But the child sells the property, right? There's still a gain. You know why? Because the step up in basis didn't happen. The child takes on the parent's starting line of 1990. So that is not a good idea to add a child to the title. What's the best way then to transfer the property to my children to avoid capital gains tax? Establishing a living trust and letting the child have that property through an inheritance. You get that extra step up in tax basis. If you simply have a will, that may not avoid probate. So yes, they'll get it as inheritance, but you might have to go through that whole court process to get there. And then of course that transfer on death deed that I was talking about, very simplified procedure. Now, before you do any of these things, there are so many things to consider, right? What's my property tax issues? What is my ultimate goal here in having my child be on that property with me? Is there any liability? Does the child have like child support payments? Like, do they have any back taxes? You know, once they're added onto that title, that becomes their asset as well. And then do you have like other children, right? Is that going to create an issue where one child gets the property and maybe another doesn't? What if you have investment property, right? You have a rental home, you have some other type of non-primary properties. Is there a way to eliminate or reduce taxes? Not really. It's more about deferring those capital gains taxes. So with the residential property, if you sell it, there's that $250,000 exemption, right? But with investment properties, you may not have that. And you do have to pay these capital gains tax. And of course, everyone has heard about the 1031 exchange, right? You have an investment property, you sell it, you have to get another one in a certain amount of time and purchase a like kind of property. And then they roll over those profits to another property and you defer this payment of the capital gains. You're pretty much kicking the bucket like down the line, right? Until a future sale. So that is one way to defer capital gains. But did you know that there's also something called a Delaware Statutory Trust, a DST? This is also a little bit more well known as well. This is for people who say, you know what, I have an investment property, I'm going to sell it, but I really don't want to buy another property. Like, I just want out. What are some other options? Well, here it's similar to a 1031 where you invest in a property or projects, but it's usually on like a bigger scale and it's like within a group. So there's special companies that have this, and it could be, I was going to hear, they are like large housing complexes, high-rise buildings, right? Shopping centers and stadiums, but it's still real estate. There's something also called It's also DST, but this one's called a deferred sales trust. Here you also have it with a project, like a company, an investment, but it works with a tax specialist, and it is more like securities in addition to real estate, and you have a little bit more control about what the investments are. So here you're going to be working with a financial advisor who's going to set that up, and a very specialized trust or tax attorney. Now, our office does not handle these, but if you would like more information about it, let me know. So which one's better, right? A Delaware statutory trust, right? They're a bigger, again, bigger type of real estate, shopping centers and such. The other type of deferred sales trust is you have a lot more control about where the investments are going to be, and you're dealing regularly with like an advisor. And the deferred sales trusts are not only for investment properties that you sell, but it also could be for a business. So, I mean, imagine like you started this business from scratch, right? And then now it's a huge business. Well, you're going to have to pay some capital gains if you do sell that business in the future. And the deferred sales trust could be one way where you can defer those taxes as well. Want to talk about Prop 19. I get this question so much because it has to do with the property taxes. Now, just in the slides before, I was talking about capital gains taxes. This is kind of like the IRS federal, right? When you sell a property and it goes up, you have to pay some taxes on that gain. But this one is what you pay to the county every year, right? And it has to do with the value of your property. This new law, Proposition 19, passed in 2021, or at least that's when it went into effect. And it's good and it's bad, right? So a lot of good stuff came with it, but a lot of not so good stuff came with it as well. Now, there's two prongs to this Prop 19. One is the transfer of the base year value for those who are 55 years and older. And then there's the other rules for when a parent transfers to their child a real property. Now, the good thing, right, is if you're 55 and older and you sell your primary house and you go to another one, well, you can transfer that old base year, the property tax value, to your new property. In the past, it really depended on which county you could go to. Now with this new law, anywhere in California, you can do it. That's good. And it also extended to, severely disabled, victims of wildfire or natural disasters. So in addition to being 55, you could also, if you're qualified with any of these requirements, you could also use this transfer base year value. Another good thing that happened with Prop 19 is that before you could only use this transfer one time. Now you can use it 3 times. It has to be a primary residence. And another good thing that happened is even if your new residence is higher or greater in value than the old one, you can still use this. It's just like a prorated calculation. In the past, you weren't able to use this if your new property was greater than the old one. So that was one of the good things that happened. So the calculation here is that if you have a replacement new primary residence that's equal or lesser value, you can just transfer that old tax value, same. If your new property is greater, well, it's a little bit of a formula, but still you can, it's what it is. It's the old base value plus the difference in value of the new one. And you still have a savings though. And it's great. You just have to fill out a form, and it has to be 2 years within that sale. Now, the parent-child exemption, though, this is kind of one of those things where I was like, it's giving a lot of my clients grief, and I know it happened in 2021. So if you transferred property, if there was a death after this date, February 16th, then this new rule will apply. Before, when you had real estate, you could go from parent to child, parent to grandchild, grandchild to grandchildren, grandparent, grandchildren, and it would just carry over that tax basis, right, from the old to the new. Now it's only for your primary home. So if you have a rental, if you have other type of investments, then those all will be reassessed to today's market value, right? And for the primary home, they also changed it so it was only up to $1 million. Anything above that, it would be reassessed and added to your base value. So what do you have to do, right? If you have a house and you want to transfer that to your kids, you have to think about, are they going to be living there? Do I live there, right? Because you only have 1 year from the transfer or date of death to move in. So, for example, I had a client who passed away and it was their primary home. Great. But they had 2 kids and one of them wanted to move in. Great. And you had to do that within 1 year. You had to file a homeowner's exemption within 1 year. And if you're able to do that, they can transfer that property tax value up to $1 million, and anything above that gets reassessed. Now, doesn't mean that all the children have to live there, but at least they must be entitled. So, for example, the trust says to my 3 kids equally, right? Maybe they'd all decide, you know what, let's just all be on the title, but only one family lives there. Great. That transfer will, the property tax will transfer over. And then maybe that one family says, you know what, I am going to move out, but hey, next person on title, you can move in. Then that keeps going, right? The property taxes. But as soon as they move out and there's really no child that lives there anymore, then it will be reassessed as of the date of the transfer. So even if you are okay and you qualify for this exemption, you have to be careful that when you move out, that you're thinking about reassessment as a possibility. Okay, so just some things to think about with this Prop 19. Okay, so here's a little bit of some strategies or hypotheticals that I wanted to run through with you. Client says they want to add their child to the house deed or give the house to the child. We went over this kind of in the beginning. The good thing is that, yes, they're avoiding probate by just adding the child to the deed, right? So it's like 3 people, joint tenants, right? The house is secure in the child's name and it's out of the assets or liability, like if you give the child the home completely. But the bad thing is that there could be that property tax reassessment. Does the kid live there? Is this an investment house, right? We do have to think about Prop 19, which, you know, a deed is easy to do, but it's all of these tax consequences that you really need to be thinking about. And then remember those capital gains, right? So now the child is an owner. They take on the parent's tax basis. So if they were to ever sell that property, doesn't matter if mom and dad dies, they would have to calculate from when mom and dad first purchased that property. So there is a disadvantage for capital gains. Also, there's no security for the parent. And you know, there could be some liability as well, right? I mean, if that's like your only asset for the parent, then you gave it to the kids. Of course, you've heard horror stories where the kids just like sell the property and kick the parents out, right? So, I mean, that could happen on the deed, right? Is the child's name. It could also be unfair for other children. Like I was saying, what if you have 3 kids and you just give it to the one child? I get this a lot. Parents are always like, I'm just going to put it in, you know, oldest son's name. He will know exactly what to do if we're not here. Yeah, that rarely ever happens, you know? And if they do happen, then, and if like, let's just say the older son is really good and he's like, okay, I'm going to distribute this equally, then they are also looking at property tax reassessment, capital gains issues, and such, right? You also have to note this on a gift tax return. Anything over $17,000 a year, you do have to do a gift tax return. Doesn't mean you have to pay gift taxes, but you have to file that return, and it's like an informational tax return. Client says they want their 2 kids to split the house equally after client dies. I get this a lot, right? I only have a house. Maybe I don't have too much cash, but I have 2 kids, 50-50, right? Is that good? Is that bad? Right? These are some things that I consider. Do you have a child that's living in the house? Right? Maybe one child is living there and one is not. And what if the one who's living there, they don't want to leave? They don't want to sell the house. What are you going to do? Are you going to have the other child kick them out? Right? And what if the child wants to buy the other out? okay, I want to live there. So, child who doesn't live there, let me buy you out. Number one, what's a fair price? Right? How are you guys going to decide on that? And can the one who's buying the other out, can they qualify for a loan? Right? Are they even working? How much is there already an existing loan plus like another loan? Are they able to handle that? Can they use some of their inheritance to buy out the other? Is there enough cash in this trust where someone could get the cash, someone could get the property, right? And if there's a mortgage, again, who's taking that on? Is that being paid off through the trust first? Does the one who lives there, do they assume that loan? This is where life insurance might be helpful. If you're thinking about, okay, there's only one house, but maybe the proceeds from the life insurance, one can get that, and the other person can live there. And if it turns out that, you know what, let's just put both of our names on the title, you can't pay me out, then is the one who's living there, are they paying rent? Are they paying the utilities? What if something happens? Are they both liable? These are all very good questions that we need to flush out and kind of determine. And then what's the timeline too, right? Oh, my son, I'm sure he's going to move out, when? Like a year from now, 5 years from now? And, what's it going to take, right? So, if you want to know about some of these solutions, come talk with me, right, for consultation. But a lot of different strategies that we used. And then, of course, what about property taxes, right? Not only do we want to think about Prop 19, but we also want to think about what is the county assessor going to say if there is one house, two kids. Remember, it's only from parent to child. That's the exemption from reassessment, not a sibling to sibling transfers. It could be reassessed if you go from sibling to sibling. Not to get too into it, but trust loans are typically used for the property taxes. And lastly, using technology is so important when it comes to providing for the next generation. I cannot tell you how many petitions or like affidavits I've had to prepare to Apple and to try to get access to these iPhones. If for those of you who have iPhones, if something happens to you, who can get the pictures? Who can get like your Robinhood account? Who can, have access to the phone if they don't know your password? So maybe if you have an Apple iPhone right now, you can go to your settings and we can set up a legacy contact. You go to settings and then you click on your name, you go to password, legacy contact, and here you can select someone from your contacts and you send them a special code so that if they're ever trying to access your phone, they can use that code and Apple will be able to get them into the phone. If you don't have that, I have done many petitions to the court because Apple will only accept a court order. And once you have to go through that whole thing of court, then Apple will allow heirs to access that phone. You could also keep a list next to your estate planning documents with passwords as well. And for Google, there is something called an inactive account manager. So if something happens to you, you say, okay, maybe like if I'm inactive for 3 months, 6 months, a year, whatever, you set it, then notify this person, and then this person will be able to have access if you are inactive for a certain amount of time. And this is the website where you can do it. Once you go on this website, it'll be like start, and then it has some instructions for you to complete that. I think the main thing to know here is that if something happens to you, we want to make sure, do the assets have a place to go, right? You can also do this for Facebook too. There's many ways to organize your estate plan, right? We want to you be strategic about holding title. This is a good time to check your beneficiary designations, right? Important to keep an up-to-date inventory of your assets. Don't forget to fund your trust. For those of you who have done your estate planning through me, right? Be sure you connect everything to your trust, right? Go to those banks, make the trust a beneficiary, or change the title of the accounts straight to your trust. And if there's any big life events, marriage, birth, death, disability, kids turning 18, right? Retirement, always review your documents and make sure they're up to date. And of course, plan ahead and plan early. If you're already incapacitated or you're not here, obviously it's too late to do anything. So doing things now proactively is always the best strategy. Marvin, do we have any questions?
We do. Let's see here. So we have one question in so far, and it has to do with actually what you were just talking about, keeping your trust updated. So the question is, um, laws can and do change, and while setting up a trust, let's say a law does change after you've set up the trust.
Mm-hmm.
How does one keep up to date with those changes? Do you have to restructure the trust, reestablish some of the,
It could be.
instructions?
Yeah, it could be. This is especially with revocable trusts, it's always a good idea to keep it updated, and especially when new laws happen. This Prop 19 was a big one, and we had to talk with clients and kind of rethink their strategy because I had this client who had a $3 million primary home in Manhattan Beach, and they're like, you know what? If I pass, yeah, it goes to my kids, but they still have to pay tax on this like $2 million, because remember it's 3 million minus the
Right.
million, but still have to pay 2 million. So we had to do some strategy on that one too. So laws are ever changing. That's why if you hear in the news like, oh, the tax rate went up, or like, these crazy things are happening. If, of course, if you're on my newsletter, I usually send out if there's any big tax changes. But attending seminars, always being educated about, just what's happening. That's a good thing, and always just being aware.
So, let's see, we have another question here. So the questions are starting to come in. What fees and costs are associated with creating and maintaining a trust? Are there any specific considerations for digital assets such as online accounts and cryptocurrency?
Yeah, I mean, all law firms are different. They have different fees, right? And if you want to know our pricing, you can contact us offline. But you want to just make sure that you have a good vibe with the attorney. It's kind of like going to the doctor, right? I mean, you're going to be talking about your finances and your distributions and your family, so you want to have a good connection with them, and feel like they understand you, right? And feel free, like you can communicate with them. I think that's important. Um, and with our documents, we always use the latest software, so we're always ahead of those digital assets. We have a power of attorney for that as well. And with cryptocurrencies, you list them as part of your assets. We have like something called the Schedule A. Basically, if you're not here, how's the next person going to know, right? And all of this is just planning so that the next person, it just makes it easier for them to handle these things. So writing it down, making sure the beneficiaries are correct, keeping passwords together. That's really what it's about.
Okay, we have another one here from Michael, and it's we have a revocable trust. How hard is it to change to irrevocable? And then are assets protected from long-term care?
It will depend, and it's easy to change to irrevocable. It's just an amendment saying that it's irrevocable, but you do have to factor in the pros and the cons of making something irrevocable. And when you talk about long-term care, you may want to talk, I think you may be talking about Medi-Cal insurance. And if that's the case, then one of the good things or benefits about having a living trust is that if your house and assets are in a living trust and you pass, especially if you're using like a nursing home through Medi-Cal, then assets within a living trust are not going to be subject to reimbursement. So they're not in your name, they're in the living trust's name. And even though it's not a like a revocable trust, it would be irrevocable when you pass. They Medi-Cal will not be able to get your family home, for example, if it's in a living trust.
All right, this one's coming from Colleen. I think Colleen's one of your clients. She says her husband passed away 3 years ago, and they have the revocable trust set up. At what point should she update the trust, will, power of attorney, etc., to remove his name?
Yeah, it's a good idea to review those types of trusts, and depending on how the trust was set up, the surviving spouse might have the power to update everything, or there could be some trusts from a while ago when the tax laws were different, where the surviving spouse does have to split assets. So when there is a death, it's always good to get your documents reviewed and updated if necessary.
So, um, Here we go. What happens? This one's from Brian. What happens if I own property in multiple states? How does this affect my estate plan? And I guess I think somebody asked me this question the other day too, and that it was if they have multiple properties, can it all go into one
Yes. So
trust?
usually the trust and will and other estate plan documents are for where you live, your residence. And then so say you live in California, it would be a California trust, but say you have a Texas, investment property, you could still put that into your California trust. And it's good because if something happens to you, the trustee of your trust has the power to, sell it and do whatever they need to do over there. If you don't do that, you might have to open a probate over in the other state, depending on their laws.
So if anybody wants to get a copy of their grant deed, just let me know. Shoot me an email or a text, because I think I texted everybody. And then we'll make sure you get a copy of that at no charge. And then I know there's some folks on here that already have an estate plan put together, but if you don't and you wanted to get a consultation, just let me know or let Sophia know. We'll be happy to make the connection for you. If you happen to know someone that may not have had an estate plan in place and need to go through a probate, let us know, either myself or Sophia, and we can make sure that they're well taken care of. I was once told a long time ago, you always have to pay. You either pay up front or you pay after. And with the estate plan, it's essentially paying up front, so you get to dictate what happens with your assets. Like Sophia was saying, it's kind of like insurance. It's a love letter to those you care about, because going through probate is a lot more costly and not much fun. Doesn't seem like we're getting any more questions, but a lot of thank yous. So appreciate it, and wish you guys the very best for the remainder of the night and the week.
All right. Take care, everyone. Thank you.
All right. Bye.
Bye-bye.